which the publishers and the publishing industry, the content industries generally, the music industry, the book industry, the software industry, the motion picture industry, are in this sort of hysteria, right, about the end of copyright law as we know it, and sort of looking for more and more robust rights to try to protect themselves against online infringement. On the flip side, we have people who are disdainful, right, of the whole idea of copyright law and this whole culture that's arisen that says, oh, screw the copyright owners, the recording industry is evil and therefore copyright should be damned, And I thought, I think it's so easy to simplify and to sort of ostracize either side. And I thought I'd just lay out a little bit the history of what's been going on and then move on to some of these author issues. I'm not going to speak for that long because I thought what I'd most be interested in hearing are your questions about what issues you're confronting. I may or may not have answers to them. Frankly, I haven't I haven't done a lot of work on library-specific issues. I have general understanding of them. I do know more about sort of more general author-specific issues, but I'd love to hear what your concerns are. All right, so let me just start with the overview. The past 15 years, as all of you know, have been incredibly tumultuous, and there are really 3 different events that you can identify as having led to where we are now in the copyright impasse. The first one was the emergence of digital technology and digital distribution of content. And what this accomplished was the ability to make essentially perfect copies, right, of these digital works with single keystrokes or single clicks, right? It enabled very easily people to make perfect second-generation copies. And this was a real change from the photocopier days, because yeah, people could use photocopiers to make copies of works, or you could use cassette tapes, right, to make copies of your vinyl records. But they weren't as good. There was a degradation each time you made a copy, and so they weren't really perfect replacements, right, for the original. They were replacements in some circumstances, but not perfect replacements. So the copyright holders started, even though they recognized the potential of this digital platform, they also started to be a little bit wary about its implications for people who were making copies and distributing. The second thing that happened was the internet, right? In the early 90s, the content owners started to become aware. This is essentially when I left practice in the late 90s, but during the period in which I was in practice, copyright holders were starting to get very nervous, right, about the emergence of the internet. And in the early years, it was these websites that would post content without their permission. In the mid-90s and late 90s, they started to actually get that a little bit under control because Congress passed the Digital Millennium Copyright Act, which provided for a notice and takedown system where copyright holders, when they identified websites that had posted content without their permission, could give notice to the website, get it taken down, pretty promptly, and at least kind of stem a little bit this flow of distribution of copyrighted work online. And then the third thing happened, which was peer-to-peer networks and the emergence of this totally decentralized form of distribution. And they've had a much harder time with that because there's no bottleneck, right? There's no single source that you can go to and say, if I go to this party, I can get the content taken down, right? In the first generation of peer-to-peer, there actually was kind of, because Napster had an index that it kept. But as soon as a court imposed liability on Napster based on that index, the next generation of file sharing networks just did away with the index, right, and made it very difficult for them to filter out content. So the content owners' hysteria is, in some ways, kind of justified. I mean, they are worried about the emergence of these new technologies that enable people to distribute their content free of charge in a way that really could substitute, and has substituted, for legitimate sales. More so in the music industry than in your primary industry. The book industry has not yet seen the same threats. But there is a fear that as we move more and more in the last few years is this real emergence of this creative culture, right? This amateur culture in which people both create their own works, right? Bloggers that create their own content, post it online, want to share it. MySpace musicians sharing their music online for free. But also a lot of creators that are taking pre-existing content, manipulating it, and posting it online. And so there are really interesting copyright issues that emerge in connection with all of those sorts of works. How should copyright law think about these amateur creators? What are they looking for, if anything, in the law for legal protection of their works? What is the relationship between these creators and the traditional commercial creators? Some people have argued that the emergence of these creators effectively, who are not motivated by commercial considerations, but purely by the desire to create and distribute and disseminate their content, suggests that copyright as we know it is irrelevant, that we don't need the financial incentives of copyright law anymore, right, to provide for authors' needs, that authors are simply going to create for their own personal motivation. I'm a little bit skeptical of that argument, but I do think that there are some important things that have happened in recent years to help copyright law, or at least help licensing law to meet these people's unique needs. So for example, I don't know if you've heard about Creative Commons, right? Creative Commons is this there's a website, there's this whole organization that has come up with a new system of different kinds of licensing that authors can choose to put on their materials when they post them online. So you can put, for example, create a non-commercial license that says, you may use my content for any purpose whatsoever, as long as you don't sell it, right? So you can reproduce it, you can distribute it, you can post it on your website, you can link to it on your blog, but you can't charge money to people for it, and you can't incorporate it into another work that is used for commercial purposes. You can also choose to have anyone use it for any purpose as long as they give you attribution, right? So it provides for a variety of different options, licensing options for people whose main goal really is not commercial, but really to try to get their content distributed, but who have an interest in limiting in some ways the use to which people put their work. Anecdotally, from talking to people who distribute content online, a lot of them really have no concerns about people replicating, duplicating their content, but they really do want to be identified as the author, right? They hate the idea of someone else stealing their content and putting it out there under their own name. And so this whole system doesn't change the law in any way, but what it does is create a system of through which authors can harness the law for their purposes through very identifiable and user-friendly means. I thought I'd just tick off a couple of the hot button issues in copyright law generally to mention them and mention their implications for authors and creators, and flag them so that if you want to explore them in more detail during questions and answers, you should feel free. I'm just going to mention some of the lawsuits or sort of legal phenomena that have occurred in recent years. One of the big issues right now, or big lawsuits right now, is the Viacom versus YouTube lawsuit, which you probably read about. This is a suit in which Viacom and a number of other copyright owners are alleging that YouTube as an intermediary, right, should face liability for infringing content posted by its users. It is undoubtedly true that there is sort of rampant infringement going on YouTube. It's also undoubtedly true that YouTube, unlike Napster, for example, was not created with the sole purpose of facilitating the sharing or the posting of infringing content, right? It has tons of very significant non-infringing non-infringing applications and is used by millions of people on a daily basis for those non-infringing purposes. And so it presents some very interesting questions about the scope and implications of copyright law and the safe harbors from copyright law that were created by the Digital Millennium Copyright Act, which is this kind of notice and take down system that I referred to before. YouTube, unlike the file sharing networks, actually does host content, right? It actually, its servers are hosting the content that is provided by users. And the Digital Millennium Copyright Act provides it immunity as long as it responds to notifications from copyright holders requesting that it take down the materials. Now, Viacom is claiming a couple of things in this lawsuit. One, it's claiming that YouTube has not adequately responded to its copyright notices. But the second thing it's claiming is really more that systems like this, whose business model is so dependent on widespread infringement, simply should not be entitled to legal protection under these safe harbors. It's asking for kind of a recognition by the courts that in circumstances where an intermediary like this one just knows, it just has to know how much infringing content is available on a daily basis, that the system should be required, should be under legal obligation to adopt some kind of a filtering mechanism, right, that filters out copyrighted works ex ante rather than taking them down after receiving actual notification from copyright holders. So it's a really interesting case for testing the limits of the safe harbor exceptions and for really testing this proposition of whether the safe harbors really do totally exempt people from liability, even if their business model, at least arguably, seems to be dependent on some level on infringement. The other thing that is probably nearer and dear to your hearts is the Google Book Library project, right? That litigation is another sort of cutting-edge case raising novel legal issues. You're all familiar with the project, right? Google's copying millions and millions of books, some of which, many of which, at least in the first wave, have fallen out of copyright, right, are in the public domain, but many of which are protected by copyright, and that's certainly Google's hope, is that over time it will have a very comprehensive collection of both copyrighted and uncopyrighted works. The question in this case is really whether Google has to get permission up front, right, from the publisher, or whether it is protected under the fair use doctrine of copyright law, which allows people to engage in behavior that would otherwise constitute infringement, but are protected, legally protected, as quote-unquote fair users. Now, fair use is notoriously impossible to define with any clarity, right? It is completely mushy. It relies on 4 different factors. The nature of the copyrighted work, the nature of the use, the defendant's use of the work, how much of the work was taken, and what the market impact is of the use on the copyright holder's actual or potential markets. There are pretty strong fair use arguments on behalf of Google, but there are some cases in the last couple of decades that support the publisher's claim that Google is not engaged in fair use. And a couple of the things that count against Google are, number one, it is making wholesale copies, right? It's making full copies of these works, even though it's only making snippets of them available to the public. Wholesale copying tends to cut against fair use generally. The other thing that, oddly enough, may cut against Google is this market impact factor. Now, you might say, look, if anything, this helps the market for these books, right? The whole point is Google Google is just identifying works that might be relevant for people's research or for people's interests. And then people are going to go and buy those books on Amazon, or go to the library and borrow the books, which can increase the demand for the books, and the libraries might buy another copy. So it's a good thing. But the way that copyright law has evolved in recent years is that if the copyright holders can identify a potential licensing market, a potential market in which they could have licensed the use of the works in this way and gotten some revenues from that use, then the copyright holders, the publishers in this case, may be able to persuade a court that they actually will suffer an adverse effect on potential revenues for potential uses of the work. And so what they're trying to argue here is there's money being made here. Google's not doing this through purely altruistic motives, right? Google is actually making advertising revenues on these works, as it does with its search engine generally. And that given the incredible value of this project and the contributions that our works make to the value of this project, that there is a potential licensed version of this kind of a project, and that we should get a cut, right? Most of the publishers would actually probably, and most of them actually have, opted in to opt-in systems that are very similar to Google's system. What they are really looking for is the right to opt in rather than to have Google just use their works without giving them that opportunity to opt in. And the reason is really just about protecting their rights going forward, to the extent that these projects really do develop into viable commercial projects. You know, they want to cut. They want to cut. So it's going to be interesting to watch that one proceed. It's in discovery, the unending discovery phase of litigation right now, but it's a very interesting case. All right, the file sharing cases are obviously another interesting area of copyright law. We can talk about those. You've probably read about those. Another interesting area of copyright law that is happening right now, and it probably does affect you in some ways, is this whole issue of streaming podcasts and internet radio. There's been a lot of discussion in the last few years about the status of people who stream content over the internet. This is particularly relevant with music, because pre-internet or pre-digital distribution, music copyright owners were limited in their rights against broadcasters, right? So it gets very complicated. There are two different overlapping sets of rights in published music. The owner of the musical composition, the person who wrote the song or their assignee, has copyright rights in the musical composition, right? But there's also a sound recording copyright that the label tends to own, right? That the recording label tends to own. So there are two separate copyrights at issue. Now, in the olden days, the pre-internet days, both of those parties had rights, exclusive rights to make copies, to make reproductions, right, of the song or of the CD. But only the musical composition copyright owner had the right to make public performances of the song, right? The phonorecord copyright owner, the musical label, the recording label, did not have exclusive rights to public performance. So radio stations could play these songs without paying royalties to the labels. They did have to get permission from the copyright owner of the musical composition, but there's a fairly standardized process for doing that. There are these groups, ASCAP and BMI, that help to coordinate blanket licensing for these purposes. With the advent of the internet, Congress created a digital performance right for the owners of copyright in these sound recordings. And so for digital distribution, for digital streams, there are two rights holders to which these internet radio stations or others have to go to get permission to stream. And that has created problems. There is a compulsory licensing scheme that's big parties, and the little guys have felt shut out, and there are a lot of internet radio stations that have just stopped running as a result. And so what you've been reading about in the newspaper is kind of the continuing controversy over whether Congress should step in, right, or whether the royalty tribunal is capable of kind of reassessing and setting perhaps rates, differentiated rates, different rates based on the revenues of the radio station, et cetera. Okay. All right, finally coming around to what you came here to hear about, which is author-focused questions in the contemporary context. I've mentioned Creative Commons. There are a couple of other issues that I want to draw out a little bit. One of them is evolving relationships between authors and publishers in this, in an online and digital age. One of the interesting things that's been happening in the law publishing community is that law professors have been getting together as a group and putting pressure on our primary publishers, which are law reviews, to allow us to retain rights in our works and allow us to distribute them, at least in digital version online, simultaneously with their publication in print form. And we've actually been fairly effective at doing that. The SSRN network has been recognized by law reviews as incredibly valuable to them, right? That it gets the word out there about articles that have been published in their journals, and really gets interest in their journals and facilitates sales. My understanding is that in other contexts, particularly commercial publishing contexts, but also science publishing contexts, that other publishers have not been so amenable to that, and that is, a problem. On the other hand, I think increasingly academic institutions have started to really recognize this as a problem and recognized it as a threat to their goal of promoting knowledge. And MIT's teaching initiative and other initiatives by faculty to try to really make their materials available online may start to increase the pressure on publishers to recognize a little bit more flexibility in how authors use their work. So whenever I'm giving advice to my colleagues on publisher relations, I usually start by giving them a form of an agreement that I've signed, a sort of marked up version of the copyright assignment agreement that was sent to me by the journal, and I sort of cross out assignment and write non-exclusive license in there. And you are, if you have a valuable work, you have some leverage, right, with at least the academic publishers, try to really identify what the author's goals are. What do you want to retain rights to do? I'm happy to, I don't know how familiar people are about exactly what the legal rights and obligations are with respect to the authors, the publishers, what the difference between a license and assignment are. I'm happy to go into those details if you'd like to hear about them. But again, why don't we wait and see if that's something that you'd like to really focus on. The final thing, actually two final things I want to mention. This whole area of fair use. Fair use, as I mentioned before, is the reproduction or other use of copyrighted material for purposes that are seen to be promoting the goals of copyright, which are promoting knowledge, right? Promoting the dissemination of knowledge. And academic authors and other authors have been increasingly limited over time by an increasingly sort of narrow concept of fair use, in part because of the phenomenon I mentioned earlier, which is the court's recognition of potential markets, right, for copyrighted works as the basis for rejecting claims of fair use. One of the ways in which this has is reproduction of articles. Right? There's a case from a couple decades ago in which a court said when a business reproduces articles internally for purposes or for use by its scientists as reference on their, the textbook, as reference, that it's infringing, right? Because it's a commercial enterprise. These copies could have been paid for because there, at that time, was the newly emerging Copyright Clearance Center, which existed to give permissions for these kinds of things. In kind of circular reasoning, the court said because there's the potential for this market to emerge, the copyright holders would be harmed if this use were allowed freely. And of course, the irony is that it is decisions like that one that actually created the emergence, or that created the value, or that justified the existence of Copyright Clearance Center. But as you know, it is well thriving and active. And so for one of the questions that I get from my colleagues is to what extent does that same argument apply, or that same outcome apply in the academic context? And I think it's tricky. I don't think that we can have confidence that every time we make a course pack, we are protected by fair use because we're acting for educational purposes. And of course, the safe thing to do is always to get CCC permission, but it's obscenely expensive. And so in my world, it's actually not that hard because most of us retain our copyrights, so I can go directly to the author and get permission to reproduce large articles, at least, in my course packs. But in the sciences, in engineering and literature and other fields where most of these works are distributed through commercial distribution or commercial agreements, it's much more difficult. I feel fairly strongly that we should stand up for our rights and try to be as aggressive as we can about asserting fair use, because if we don't, existing practices will be treated by courts as the norm. And so the more that we kind of concede fair use for purposes of self-protection, the more that it will continue to be eroded. All right, final point, libraries. Libraries have their own, a number of provisions in the Copyright Act, but have a specific provision in the Copyright Act that protects them to a certain extent in copying works for a variety of purposes. Section 108 of the Copyright Act applies to libraries, and it allows for the making of no more than a single copy of a work for non-commercial purposes. No one seems to know what that means. Does that mean one copy one time? Does that mean one copy for one scholar? And I actually tried to do some research on this once and literally found nothing. So, I don't know what to take from that, other than as a general matter, these things tend to turn on whether the behavior is likely to have an adverse market impact. And so, and there's some dictum in some Supreme Court, in one dissent in a Supreme Court opinion, that suggests that this provision is less likely to apply if the entire work is copied. I have a fair degree of confidence that if you're helping people to make photocopies of portions of a work on an ad hoc basis occasionally, that you're okay. But when you start making copies of entire works for convenience, or because you are having regular demand for multiple copies of the work, and so you think, if I make 10 copies and send them out to people, those can substitute for the original. That's the kind of thing that could start causing problems. There's another part of Section 108 that allows for the making of copies of works for replacement purposes, but that one really only applies if the work is unavailable. So for works that are no longer being sold, you can make up to 3 copies of the work for the purposes that I just described, to make them available in your collection, but not if you can purchase the substitution copy in the marketplace. And again, the concern really in a lot of these cases, it goes to whether you are interfering with the copyright holder's ability to realize its traditional market, right? Its traditional market for sales. Final question, final point is orphan works. Orphan works are works that are still protected by copyright, because what isn't protected by copyright anymore, because Congress keeps extending the copyright term, but where it is the work is out of print and it's impossible to identify the copyright owner for purposes of getting permission to reproduce it. Congress is starting to recognize that this is actually a problem that has resulted from its continuing perpetuation of the copyright. And the Copyright Office wrote a report a couple of years ago that said, you got to do something about this, Congress. Nothing has been done yet, but over the last couple of years, some bills have been introduced to Congress to address the orphan works situation. And I suspect what's going to end up happening is some kind of legislation that turns partially on how long it's been since the copyright was granted, how long it's been since the work went out of print, that is going to require some form of notice to be given, public notice that seeks the copyright holder, some kind of efforts proven to identify the copyright holder. And if you've made best efforts to identify the copyright holder and haven't been able to do so, then you're likely to be protected. But the details remain to be ironed out. But I think I have a fair degree of confidence that in the next few years we will see some movement on the orphan works issues. Yeah.
There's no way right now to identify
fair use.
that.
Oh, there's no,
The orphan, it affects us actually.
I'm sure it does, yeah. And so right now, the way in which you're protected is through the fair use doctrine. And there have been a couple of articles written in the last 5 or 6 years arguing that that time or the orphan work status of the works, or how long the work's been in copyright, or the orphan work status of the work should be taken into account in assessing fair use. And it wouldn't surprise me. I haven't seen any cases addressing this issue because the copyright holders presumably, aren't around. But I would have, and I should say, I can't give legal advice.
No, I didn't.
So you should talk to the University Counsel's Office on this.
That would be
you better take that off on the online version of this recording. But those chuckles. I would love to make an argument to a court as to why people should be better protected under the fair use doctrine if they've done everything they can to identify the copyright holder, give them some form of remuneration, and haven't been able to do so, right? But there is no clear resolution yet. But you are protected to some extent under Section 108, in making a limited number of copies of the work. I don't know what.
But Amy should explain the particular project that makes this interesting for us.
Well, we're looking for works to digitize through the Internet Archive, and we know we can do our things that are out of copyright, but we've got lots of things that fall into that orphan works category.
So this is an archive that would be available to the public. Yeah, that's the problem. That's the problem, right?
Why.
Because
So they wouldn't be limited use. They would be out there.
Yeah.
In that Internet Archive that exists out there.
Yep.
So we have the opportunity to digitize works at a reasonable price, 10 cents a page.
And we're happy
From
to
the
select
Internet
works in the library that we know are used that were published before 1923, but there are a lot of works that were published in 1924.
Yeah, there are lots.
And that's fine, where the copyright owner is untraceable.
Yeah, I mean, so this is actually one of the, this actually circles back to the discussion of the Google Book Library.
Right,
Because this is one of their strong arguments is, imagine the transaction costs for what the publishers are looking for, an opt-in system, right? Because that would require Google, or does require you, right, to seek permission up front for every work. You know, it's a tricky issue. I cannot give you advice on this issue because it really is such a cutting edge, you know, and unresolved question. And it's particularly problematic because of the scale of the distribution that you're facilitating. You know, it'd be one thing if you were trying to use it for internal purposes, which would limit, you know, you could limit it to research purposes, to educational purposes, but when you're making something available on the internet, it's a, you know, it's a very different situation.
We're doing this with all the libraries in the Boston Library Consortium, so they're all facing that same.
Do you have pro bono counsel on this? I would actually recommend getting pro bono counsel.
Or not pro bono.
You're paying.
I work at the university.
Oh, okay, that's a chuckle.
Oh, all I'm saying is, we've been involved in this and we continue to want to help. I guess yeah, we can talk about more.
And and it is an totally unresolved issue. So
It's tricky, and it's like everything is moving. It's just as you say, the technology changes, the new systems are popping up. You know more about this than myself. I don't want to get into it, but it's a really important project here, and we want to find a way to make it work. That's the bottom line.
Yeah, I mean, I would think that because this is a whole Boston area, consortium, that it would make sense for all of the University Council's office to work together, you know, potentially with an outside.
One thing we know is that some of the institutions involved in the consortial activity are taking a more aggressive stance than others. We know that the marine biology labs at Woods Hole have been very active working into material that still falls within the copyright period, and essentially saying, we'll do whatever's necessary if people identify themselves. But then,
yeah, I mean, that's one possible thing that
right.
yeah, that you could do, I suppose. You know, it doesn't eliminate the risk, but it does make, I mean, one of the things in these cases is you just want to look reasonable to the court, and in the event you end up in litigation, you want to look like the good guys, right? So that's one of the things that Google has gravitated toward, is a takedown approach where it says, you know, we will certainly remove anything that anyone wants us to remove, and you could, you know, have at the front page of this project, you know, a notification that says, you know, in some circumstances we've made every effort we can to identify the copyright holders have been unable to do so. In those circumstances, we're posting materials, but please, you know, we're happy to work with you. And you know, I'd love to be the author who goes to court on that one. I mean, I'm sorry, I'd love to be facing the author who goes to court on that one.
W.B.L. Huey argued that there's an even stronger case of the common good that is being served by making some of these obscure biological and chemical texts available that were unavailable.
Absolutely.
You know, it's not limited to books, because we're working on a project now in the archives to digitize images, and the images were given to us by a local organization, Freedom House. Sometimes they have copyright information on the back, sometimes they don't. Freedom House turned over the copyright, as far as they held the copyright, to us, and then we want to make these available on the internet.
So some of, and for images, they may not even be protected under copyright, right? If they're old images and were published without copyright notice, they actually may not even be protected.
Yes, although one really tricky thing is that, although not identified on the back, I know that some of them were taken by Irene Schwachman, a local photographer who's since deceased, and that she held the copyright to some, but not all of the images she took. So it can get very
Messy.
messy.
Yeah, so I mean, I would encourage you, I know, you know, the transaction costs are extraordinary, but I would encourage encourage you to, make best efforts, certainly, to identify the copyright owners in the works. And beyond that, it's a totally open question.
Yeah.
What a part would do. I just think you want to do everything that you can to look like you've been as reasonable as you
Right.
can, and just want to benefit the public through.
Well, I think that's what that project is
Yeah,
about. Yeah, it's just
absolutely. And that's what copyright law is supposed to be about, right? And publish, as a practical matter, most of the cases that have really tested limits and created these dangerous doctrines have not involved circumstances like these. They've involved commercial actors. Publishers don't like to go after people like you, Not to say that they won't, but Google is in a very different position than universities.
Didn't both going after Dogan?
Yeah. They did, but notice that they went after Noman instead of the internal copy. And your reprographics, and they did that for a very important reason. Fair use. So, to get into the doctrine of fair use, the first factor of fair use, which is the nature of the use. The two critical points on the nature of the use are whether the individual making the use was acting for commercial purposes and whether the use was transformative. And if you were acting for commercial purposes, it's presumed to be unfair. You can meet that presumption, right? You can overcome that presumption, but it's presumed to be unfair. If it's for non-commercial purposes, it's presumed to be, it's not really presumed to be fair, but the copyright holder has a burden of establishing that you had, and were likely to have an adverse impact on it. And so it really changes your position, and that's why in the Noman cases or these copy shop cases that they went after the commercial copy shops, even though the commercial copy shops were making these copies for professors, right, to use in their classroom. Fair use analysis turns on who is making the copies, who's doing the act that's described in the Copyright Act of making the reproduction. So you can't stand in the shoes of the person for whom you're making the copy. It's a question of whether you're acting for commercial purposes in making the copy. However, the Google, although this is different from Google because you'd be making the whole work available.
Right.
Yeah.
Right.
So that actually makes you for that purpose, you're sort of in a worse position than Google, but from the commercial side of it, you're in a better position.
Right, but we are working with the Internet Archive, which is a non-commercial.
No,
And there
absolutely.
was, I have to ask Will, there was.
No, I'm busy with the biscuit.
There was the opportunity to digitize these works through Microsoft or?
There was a facet of the original negotiations that involved Microsoft as one of the players.
And they decided not to go with them.
Because
Because they're commercial.
the Microsoft requirement was that essentially the Internet Explorer be the approved browser which all this material had to be viewed
Of course.
through.
Yes. So I mean, in a sense, we went with the Internet Archive, which is non-commercial, so that might be.
Yeah,
In fact, we're paying.
Yes, that's right.
We're paying to do this. We have to pay 10 cents a page, so.
You're paying for the work that you can identify the copyright.
Well,
We're paying
for
for
the
the digitization.
And
Yeah, but the question that the publishers would say, yeah, but we're not getting that, right?
Oh, yeah.
So, what are you doing with respect to the works for which you can identify the copyright holder?
Well, we've been exclusively working with material that's pre-1923.
Yeah, that's what
So it
we're
hasn't-
saying.
this
Well,
is
we
like a
haven't said it yet,
hypothetical
but
for
we
us.
will be soon.
Mm-hmm.
But there's a discussion of the orphan works. That's what you mentioned. I didn't mean to interrupt.
No,
But,
that was my last point, so this is a good time.
So there are actually on Tuesday, I think there will be discussion at the BLC meeting about that issue of orphan works. So I don't know who's speaking, because it's still up in the air. We have all these other things we could digitize, but we're reluctant to do.
Mm-hmm. Mm-hmm.
So you're saying it's so new, or it just hasn't been decided yet?
That's right. That's right. And so the cautious approach would be to wait and see if Congress acts. The argument I was making a few minutes ago about how we should be aggressive about trying to protect our fair use rights would would argue the other way.
But for instance, it
The-
might not be prudent to go ahead and just hang on to the digitized files, awaiting the day when there is some legislation that enables us to make use of the material.
Yeah.
But if
Yeah,
you've
no.
made the copies, isn't that still?
Yeah, that's infringing,
Right.
essentially.
Well, it's not, no, I wouldn't say it's
Well-
infringing, I would say it is an act of reproduction that is, unless it's protected by fair use, is infringing. But actually, you know what, if you make the copies, you're protected by 108. It's only when you actually are making them available in digital form that you're not. So 108 actually does allow for the making of digital copies, but not for the distribution beyond
Right.
your premises.
Right, we could
So-
argue it was for archival purposes, for instance.
Well, that would be disingenuous, but,
No, we do plan to retain a file,
Yeah.
a master file. for that
okay,
purpose.
okay, so it wouldn't be disingenuous.
So-
But, you know, but no, I would absolutely feel completely comfortable doing that, because that copy would be protected, and then you can see, and that would get you a head start, so that if you decide to move over to the next stage.
Right.
Yeah, I would, that's probably what I would do, but I'm not giving you any legal advice.
Right.
Thank you.
Do I understand that they moved the length of the copyright back further, which has created these orphan works, right? It's created like a longer time.
Well, the thing, there are a couple things that have created the orphan works. One of them is the orphan works problem. And it's only gonna get worse, by the way, because one of the things that's created the problem is that we signed on to an international convention in 1989, the Berne Convention, that required us to eliminate copyright formalities. This has been the rule throughout most of the world forever, or for at least over a century, that people are entitled to copyright protection without regard to whether they publish their works with notice of copyright, without regard to whether they register their work, you know, blah, 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 blah. We had to completely eliminate the formalities requirements that we used to have. So we used to have this rule that if you publish a work, you need to publish it with a copyright notice that identifies the copyright holder and the date of first publication. And now we don't have that anymore. That's not what's causing the orphan works problem for the old works. The orphan works problem for old works was really created by the fact that the copyright term keeps extending, and there are all, you know, millions of works out there that have no commercial relevance at all anymore, that haven't been published in years, and whose authors have died, you know, long since died, whose publishers have gone out of business, and no one filed anything with the Copyright Office identifying who the heirs are, you know, who.
Would it be possible in theory just to say, look, this is a rule that has changed and put out this call, but if you still want to be involved in this, if you still want these benefits, then you opt in at this point.
Yeah, so there have been some calls for that. Larry Lustig, who I'm sure you've heard of, has argued in favor of having a renewal system that says, you know, after 10 years, which is really the relevant time, you know, after 10 years, most works lose their value. And he said, you know, let's just have people pay $1 and in order to renew copyright for works after 10 years, and that will mean that for the rest of the vast majority of works, the public can have access to them. Great idea. Yeah, I mean, if this same Congress that just extended the copyright term for the life of the author plus 70 years, is confronted with this proposal, is it likely to do it? I don't know. I think it's much more likely to adopt something like a more limited orphan works proposal that says, that doesn't focus so much on the copyright holder and say you have no rights, but that focuses more on the user and says you are protected if you've done everything you can to identify the copyright holder. You've been unable to do so. And the difference between the two is that the user-focused one would probably give the user protection only until the author comes in and says, actually, I'm here, I do exist, and I really intend to assert my rights. And so that's, you know, the orphan works proposal really is just an insulation from liability for as long as the copyright owner is unknown. But in those circumstances, you know, presumably the proposals that I've seen would enable copyright holders to step in and identify themselves, after which permission would have to be obtained to use the mark.
So we're coming to the end of our time here. Obviously this has gotten some good discussion going, and I don't know if you're available to stick around a little
Yeah,
bit.
I can
People want to
stick
stay and continue the conversation. I just wanted to thank Stacey Dogan for coming here today. It's obviously a very interesting topic that we're all interested in hearing more about and talking about, so thank you very much, Stacey.